counsel. Justice Thomas, anything further? Justice Alito?
I take it your short answer to Justice Sotomayor's hypothetical, where let's say the survey shows 25%. Let's say it shows 30%. Your answer is that has to go to a jury.
Well, we cited the Dark Knight case, the Forbes case that was resolved on Twombly.
Would it go to the jury or not? Can you give me an answer?
I think it would probably. I mean, it just depends if there was something wrong about the survey, but I don't know if it would not go to a jury. It could go to it could be resolved on summary judgment. It
would go on summary judgment
in
favor of the Republican Party or the Democratic Party.
Well, depends. Unless it meets 12b-6, it survives a motion to dismiss.
Let me give you some other examples that are in the briefs. I'm sure you're familiar with it. So this is from the Electronic Frontier Foundation's brief. So here's a poster. Let's say this is on a T-shirt. It says diamonds. It's got a picture of two hands. One has a diamond ring on it. And at the bottom it says, your purchase of diamonds will enable us to donate a prosthetic to an African who lost his hands in diamond conflicts. And at the bottom it says De Beers, from her fingers to his. Let's say that's on a T-shirt. What about that?
Well, I don't think that's going to be likely confusing. If it's diluting, it will have an exception for fair use unless that does not look like a trademark use. But if that becomes a line of books, movies, TV shows, and you're selling all kinds of mugs and coffees, then you would not have the fair use exclusion. But yeah, the more it says something ridiculous or condescending about the brand, it's so likely to not be confusing. You always run a chance that you might have a dilution claim, but there's a fair use exception and a non-commercial use exception that are pretty robust.
Could any reasonable person think that Jack Daniels had approved this use of the mark?
Absolutely. That's why we won below.
Really?
Yes, but
let me envision this scene. Somebody in Jack Daniels comes to the CEO and says, I have a great idea for a product that we're going to produce. It's going to be a dog toy, and it's going to have a label that looks a lot like our label, and it's going to have a name that looks a lot like our name, Bad Spaniels. And what's going to be supportedly in this dog toy is dog urine. And you think the CEO is going to say, that's a great idea. We're going to produce that thing.
No, but Nationwide ran a Super Bowl commercial with a dead child in it, and they had to pull it because it was such a bad idea. I don't know who approved that one. It was really embarrassing for them.
So a reasonable person would not think that Jack Daniels had approved this.
I think if you're selling urine, you're probably going to win on a on a 12b-6, but you're probably also violating some state law. But sure.
No, you're not selling urine. It's exactly this toy.
I'm sorry, I thought it was.
No, it's exactly this toy.
Urine. I'm sorry.
Which purportedly contains some sort of dog excrement or urine.
Okay, my bad.
The CEO is going to say, this is a great idea.
Well, just showing how confused I was suggests that I would be your perfect consumer. Justice Alito, I don't know how old you are, but you went to law school. You're very smart. You're analytical. You have hindsight bias. And
I went to a law school where I didn't learn any law. So no.
Okay, but it's just a little rich for people who are at your level to say that you know what the average purchasing public thinks about all kinds of female products that you don't know anything about, or dog toys that you might not know anything about. And so I don't know.
I had a dog. I know something about dogs. The question is not what the average person would think. It's whether this should be a reasonable person standard to simplify this whole thing.
So since 1976, you've had this appreciable or substantial number of confusion. And again, I think the best example is just you can enact a rule that says likelihood of confusion by judges or likelihood of deception. And if you think that's the average reasonable judge, okay. But I don't know how you would do a survey on that. And if you think there's something wrong with the survey, you can dismiss it. The court in Booking said surveys have to be done with careful design and careful reading. And the court can reject the survey.
Well, I'm concerned about the First Amendment implications of your position. And you began by stressing that Rogers is atextual, it was made up. There is a text that says that Congress shall make no law infringing the freedom of speech. That's a text that takes precedence over the Lanham Act. And you said there are no constitutional issues. But your answer to Justice Sotomayor's hypothetical tells me there are important constitutional issues.
Allow me to push back with the founding. Trademarks have been around since the 1500s. They predated the First Amendment. Same way with copyrights. And this court has had 4 cases, the San Francisco case, the Zucchini, and then your Eldred and Harper and Row. And you've said on all 4 of those cases, even if it didn't involve confusing speech, it didn't involve any kind of intent, it didn't involve any kind of those were all harder cases. And so it's a property right. I agree when you don't have property rights, but the definition of a property is it's going to infringe someone's speech. It is a limited monopoly as long as alternative.
Well, is it your argument that anything so long as something is protected by the Lanham Act, there is no First Amendment issue?
Well, when you say, I think that unless you're going to bring it as applied, you have to, it's confusing speech and it goes to the dilution. But yes, I think the Lanham Act is clearly constitutional. You've all but held that in the San Francisco case.
No, the question isn't whether it's constitutional. The question is whether it should be interpreted, and this is where Rogers may come from, in a way that does not bring it into conflict with the First Amendment.
Well, then you should strike the statute as either facially invalid or as applied to a dog toy. It just seems that you're overturning centuries and billions of dollars of brand investment as to confusing. What I hear you saying is that you're worried about, you think, are non-confusing uses, but courts have been, I think we cited it on page 25, case after case that rejected parodies. Notably, none of those had survey cases. There are lots of famous cases where the court rejected likelihood of confusion. And as to dilution, again, there is a Supreme Court case on point, the San Francisco Athletic Association case.